Hello and welcome to Insight. I'm Kusum Wijetilleke. My guest today is Dr. Gehan Gunatilleke, a commissioner for the Human Rights Council of Sri Lanka. Dr. Gehan, thank you for being here. And you're also the first returning guest on Insight. So thanks again for the double appearance.
Yeah, thank you for having me.
So Dr. Gehan, you've been a commissioner of the Human Rights Commission of Sri Lanka since June 2023. Human rights seems to be a regular topic of discussion in Sri Lanka from various things, from the pogroms, 70s, 80s insurrection, separatism, police brutality, and forced disappearances. More recently, the Yuktiya drug enforcement program. Can you tell us, I mean, even this government, just this 1.5 years, the High Security Zone Act, the Anti-Terrorism Act, which you came the last time around to discuss the Anti-Terrorism Act. What's the state of human rights in Sri Lanka overall? I mean, we seem to have a lot of very old institutions, laws, customs. But there's always so many deficits that we come to see day-to-day life when it comes to rights and, I guess, justice and accountability. What's the deal with Sri Lanka's human rights situation?
So I think, so first of all, thank you for having me on the show. I think you mentioned institutions. And if I were to distill Sri Lanka's challenge in terms of human rights, I think it's fundamentally an institutional challenge. So all the laws you mentioned, yes, some of those laws are very problematic. They are overbroad and they can set the stage for violations of human rights. But you also have laws that are actually model laws that are actually modeled on the international human rights standard. A classic example would be the International Covenant on Civil and Political Rights Act of 2007. That law is more or less word for word a replication of the International Covenant on Civil and Political Rights. So here you have the law really reflecting the best practice or best standard out there. But then look at Section 3 of the Act, which prohibits incitement to violence against a particular community. Look at the amount of inconsistencies and abuse in terms of how it has been implemented. And that is a classic example of a problem that is not down to just the text of the law, because the text of the law doesn't seem to have a serious problem. It's down to the institutional enforcement of the law. Right. So I think if we were to really think about Sri Lanka's human rights situation and the challenge that is faced in terms of human rights, it really is an institutional challenge. And reforming institutions has to be the number one priority as far as human rights is concerned in the country.
So on the online safety, before we get to the specifics of the online safety bill, I just want to break down some of the core issues as I see them. So regardless of the medium of communication, and generally speaking, I may be a bit of a devil's advocate here, but society generally should attempt to reduce the spread of misinformation and falsehoods. I think we can both agree on that. So there are laws as it is that restrict what you can print in a newspaper, what you can air on a television program, etc. So we have laws against defamation, libel, that sort of thing. So then the problem around social media revolves around the publishing issue and whether we treat the platform as a publisher. And then the other problem is that that this information is disseminated very fast. But I assume that everyone has a right to an opinion. And if they have a social media account, they have the right to express that opinion. And also, they have the opportunity to have that opinion heard by those who follow them. So in this, based on those sort of wide barometers of what is the online safety bill, this specific OSB version trying to achieve that you see? Or as a commissioner of the Human Rights Commission, how do you view that?
Yeah, so you mentioned something interesting in that question about the fact that laws are in existence already to allow people to respond to and contest things that are defamatory. Right? Now, let's take that as an example. The law that actually exists is not criminal law. Okay. You don't involve the state and the police as an institutional actor in ensuring that X doesn't defame Y. Instead, you have a civil remedy. So if a newspaper defames a person, that person can take the newspaper to court, file a case, prove their case before a court of law, and then get damages if that person wins. you don't involve the police in a criminal investigation. No one is at risk of going to jail and facing incarceration. And I think that's an infinitely better way of dealing with speech-related challenges. Because after all, as you mentioned, everyone has the right to the freedom of expression and opinion. Sometimes you get that exercise wrong, and people should have a remedy against you. But it's best that that remedy sits in the civil law domain, where a court of law can determine the outcome of a particular case and a claim.
Okay.
Leaving that remedy within the domain of the criminal law and necessarily the police is dangerous because, as I said before, we first need to reform our institutions to ensure that laws are actually enforced in good faith and not in an overbroad or excessive manner. Going back to the ICCPR Act, we've had 17 years of this act. And I don't think there's been a single successful prosecution and conviction of someone who's actually incited violence against a minority community. Although we've had that occur in Sri Lanka on repeated occasions, right? We've not actually had that. So the purpose of the law has not been served. Whereas you've had numerous occasions on which persons who are accused of blasphemy, of offending a particular religion, have been arrested under the law, only to be released subsequently when people realize that you can't use this particular law to criminalize blasphemy. And in fact, the Supreme Court recently, in a landmark judgment, said that this law is not a blasphemy law. Right. It was in the Ramzi Razid case.
Yes.
So really, my answer to your question is, there should be remedies. There must be remedies for speech-related challenges. But these remedies must not be dependent on law enforcement getting involved, because we have a serious institutional problem in the country where laws are applied in bad faith.
Right.
And until we resolve that problem, we should be confining our remedies to the civil domain. And even say we do reform our institutions, there's a bigger question mark as to whether people should be put in jail for the things they say. And if I were to say concretely what should result in criminal liability, it should only be in instances where you are inciting others to commit violence. If your speech is actually inciting physical harm to other people, I think then you might be able to argue that that deserves criminal liability. For everything else, there are alternative remedies in the civil domain or in the regulatory space that are much better. So if, for example, a broadcasting authority or a broadcasting company issues statements that are defamatory or issues statements that are false, maybe their license should be reviewed. But no one should be going to jail for it, because jail time is an extreme measure, extreme penalty that is often disproportionate in terms of the actual harm that speech will cause. Which is why I go back to the point, incitement to violence is the one thing that we do need criminal remedies for, criminal law remedies for, which unfortunately we don't see enforced in the country.